So I think we could start the further panel. After some lunch, there's good place for further food for thought. And this time we take competition law, EU competition law, and the DMA to see if they may anyhow interact with the free flow of information. And in that extent, we have 5 excellent presentations that we want to put in a sort of sequence to put a story, also to put it in a broader context of today's conference. So we will start with Maciej Bernatt from University of Warsaw, who will touch upon the triangle of competition, democracy, and human rights, and see how these could contribute to protecting pluralism and health in digital age. Then we continue with a presentation by Kati Czereś from University of Amsterdam. Kati will take a more consumer citizen approach to free flow of information, and she will also address that matter from the perspective of more enforcement side. So we'll also have already nice discussion with the previous panel, I believe. Then we continue with Katarzyna Sadrak from the European Commission, who just made it on time from the airport because of the delayed flight. So thank you, Katarzyna, for making it. And Katarzyna will discuss the DMA and national competition laws and see whether there are any synergies and opportunities between the two systems. Then we go with Andrzej Blażo from University of Bratislava, who will trace the silhouettes of competition law private enforcement in the DMA. So I think first Kasia on public side, and then Andrzej will continue on private enforcement inspirations regarding the DMA. And last but not least, also highly contextual presentation by Iga Małobęcka-Szwas from University of Warsaw, who will look at the interplay between the DMA and the GDPR and see whether the GDPR is a barrier limiting the effectiveness of DMA's data obligations. So we look forward to fruitful discussions. We also do hope to have some time for questions from the audience or maybe from the other panelists. But without further ado, Maciej, the floor is yours.
Thank you. Thank you very much. Many thanks to Katarzyna, to Miłosz, and to Igor for organizing this conference and for inviting me. Can you hear me well? Yeah. Like this, maybe better. Yeah. Okay. Let's try. So I was when we were discussing how to approach this panel with Miłosz, we thought that maybe it's good that I start with this kind of a very broad frame. So I wanted to discuss with you the relation between competition law and democracy. And since this is really a great conference, interdisciplinary one, I thought that maybe to start with, I would just give you the short overview where we are with the debate. Because I think when we look at the previous panel, when we discussed, for example, DSA, and I think we all agree that we need to kind of get closer to one another. So I guess this is also the role for the competition law. So very briefly, for many years, I would say that competition law was perceived in a quite narrow way in the EU. When we are discussing the goals of competition law, the focus used to be on the protection of consumer welfare, and the questions of any broader role to be played by competition law, maybe in line with its historic roots, sort of appeared quite recently, I would say. So today, as competition law scholars, we discuss the role of competition law vis-a-vis sustainability, vis-a-vis privacy, vis-a-vis combating poverty, inequality, and also democracy. And I think that there were a couple of triggers of this debate. One of them, which is perfectly in line with the topic of this conference, the rise of digital platforms, but also climate crisis. And I think for the people from the region, and for me at least, it was the notion of rule of law crisis and democratic backsliding, where you could actually see that the eroding role of competition law in the region can have just not only negative effects on the markets, but also on the democracy in a broader sense. However, this relation between democracy and competition law, I would say it was in the literature. It was very often framed on a quite general level. And in my research, I am trying, and it's still work in progress. I'm trying to really look at the instances where competition law could play a pro-democratic role on a more kind of concrete empirical level. And just to give you the taste where we are, if you look at the General Court judgment in Google Android, so the case is decided under, I would say, classic competition law scenarios. But then at some point, the General Court is saying that if we look at this case, if we look at the problem of how the search engines are organized, it's also about ensuring plurality in a democratic society. So there is this broader frame. The question is whether it is just this broader frame, or it might be really at the heart of competition law. And so far in my research, and this are again the topics that were already touched upon, I believe that we can discuss this pro-democratic role of competition law with respect to media markets, in particular media market concentration, and with respect to enforcement against state-owned enterprises, particularly in the context of the countries that are subject to the processes of democratic backsliding, and other firms that would have very strong political connections. So this is where I kind of start from, and this is where I'm going, and I want to discuss with you the project I started with a colleague of mine, Dr. Joanna Mazur, where we are asking the following questions, and this will be close to this digital world, which is relevant for this conference. So we are asking the question: if social media platforms are addictive, and if this is the firm's business model, what harm is at stake, and what competition law can do about this harm? And maybe if we look from this perspective, this can help us in better understanding the relation between competition law and democracy. So addictive platforms and the harm that it is at stake, and the question about any role for the competition law. This is work in progress. So we first rely on the scientific studies that confirm the addictive nature of platforms that was already alluded to. For example, in one of the study, we found 1/3 of young respondents show patterns consistent with social media addiction, like neglecting work, family, or school for social media use, multiplying times a week, spending more than 2 hours every day using social media. There are also studies showing the relation between the depression and the use of social media. So this is the first about the addictive nature. I think we all suffer this. I don't know. From this, and the second thing is really about the business model. Could we argue that this addictive nature is really at the core of the business model of the social platform? Because if you consider how they earn money, is basically they earn money by keeping people long online. The longer people stay on use social media platform, the better it is for them, for their financial interest. So that's the first point. Then we move to the question concerning harm, and here the question is about health. And if you look at the Article 35 of the Charter of Fundamental Rights, we will find there that protection of health shall be ensured in the definition and implementation of all union policies and activities. So competition law and competition policy shouldn't be an exception in this respect. And there are studies showing that indeed there is this negative. We can talk about the harm concerning health. The following point is a question, and here the relation with the democracy comes up. Is the question about the addiction also as a way of keeping people online. And there are studies showing that the longer you stay online, the more radical you become. So a certain extent of growing polarization that might be linked to this addictive nature of platforms. So if you look from this perspective, and this is business activity, we are talking about the platforms that some of them have a dominant position, and I know that many things can be done under the regulations like the DSA, but I don't think that this in itself should limit the potential role of competition law in this respect. So where we are looking, and I don't know how I'm staying with time. So what we are doing at the moment is try to really think about what kind of scenarios, what kind of theories of harm under competition law could we take into account. And we think that this problem could be addressed from the point of view of exclusionary practices. And here you can think about the scenario of a less addictive platform that would like to enter the market, and you have this incumbent that might be willing to become even more addictive, because this would basically serve as a platform for entrenching its market position. Or you may simply think more broadly about a development of services that would satisfy people's needs to socialize without forcing them to do so primarily in the online world. So from this, so the problem could be addressed from the point of view of exclusionary practices. The other approach would be to think about exploitative practices as exploitation of consumers that are using platforms that can we could argue that in this particular context we define the notion of quality and degradation of quality. We link it to the health deterioration, or which would be, I guess, more in line with the approach taken under consumer law, and maybe also in the DSA, that we are discussing imposition of unfair terms, so lack of disclosure of addictive features of the social platform. So this is where I am. This broad questions: democracy, competition law, fundamental rights. But I am trying so far, with my research on democratic backsliding, rule of law crisis, and competition law, media markets, and this is sort of a third path I am taking right now to see where kind of concretely you could see a potential pro-democratic role of competition law in the context I discussed for the public debate that is not polarized, and in terms of fundamental rights, a proper level of protection of right to health. Thank you very much.